through this statute. It's a very relevant statute, especially for understanding international law, right? And this entire process of codification of international law, the international legislative part, right? Lots of states has objections, but the outcome was very fruitful, particularly in terms of laying down the Vienna Convention on Law of Treaties, right? 1969, ultimately implemented by 1980. And Vienna Convention on Law of Treaties is quite a relevant document for our purpose to understand. It, for the first time, codified the method that can bring out like the the requirements of what can be treated as treaties, right? It's a very relevant, uh, like piece of legislation, Vienna Convention on Law of Treaties. In fact, the entire Vienna Convention on Diplomatic Consular Relations, that also is a credit to International Law Commission. Your United Nations Convention on Law of Sea is a remarkable achievement on behalf of International Law Commission's effort. There are many, right? Various human rights documents, you will find reference of the efforts that has been put by International Law Commission. Already I've been informed, like I have informed you this particular aspect in the earlier class as well, that it has played a very significant role. And it is a matter of prestige for any international scholar to be called by this particular commission, especially under Article 2. Right? If you are part of this particular commission, you are a very reputed international law scholar. Right? Many people are involved into this, and there are a lot of efforts that has been taken into an account, not just on behalf of what has been recommended on behalf of General Assembly or Security Council or yeah, I think in between, right? Audible now? Yeah. Am I audible now? Because there was this disturbance in between. Internet connection. Now audible. Perfect. Thank you, Vita. Chalo. So, yeah, we have to live by these times, right? Anyway, so I was discussing about the role that International Law Commission has played. The International Law Commission has played with respect to, and please do let me know if there is any breakage of voice in between, right? So international law has played, particularly International Law Commission has played with respect to development of international law, right? It's a very important effort that has been made on behalf of world altogether. We will not be appreciating it in the significant manner, but if you can read the provisions of Vienna Convention on Law of Treaties, right, particularly section 53 and 54, there are very important uh, those are very important provision, and it says that anything which goes against the peremptory norms, right, the us cogens part, this will not be forming part of any particular treaty. In fact, it goes a step ahead, and it says that if there is a treaty which is formulated in near future against the principles, the existing peremptory norms, it will not be considered as a proper treaty. Otherwise, you can agree, you like, if you look into the definition of treaty, it covers every aspect over there. A written document between two parties, right? Under the contractual terms, the normal definition that you can find. So it is not just treaty, conventions, any form, like protocols, whatever, right? But it says that any particular treaty which might be coming in future against those peremptory norms, that will be held illegal, void. And any particular treaty which is in existence, right, which was formulated before Vienna Convention on Law of Treaties, but is in existence and is against the peremptory norms of the peremptory norms of international law, that will also be, to that extent, will not be treated as a valid treaty, right? Am I audible, right?
Yes, sir.
Okay. Yes, sir. Yeah. So this important effort, right, for the first time, and Vienna Convention on Law of Treaties has attained the status of customary international law, right? Meaning thereby, even if there is a state who believes that they are not party or member to international organizations, or like to any groups, then also they are bound by those particular principles, the Vienna Convention on Law of Treaties. So wherever they will, and for the world altogether, for any particular forum that is settling a particular dispute, wherever there will be a reference of a treaty and its interpretation, you have to refer to Vienna Convention on Law of Treaties, particularly Section 53, Article 53 and 64, which I have referred. Preemptory norms, us cogens, I have already covered in the early introductory lectures. Those are norms which do not have any further derogation, right? There are doubts and debates, right, with respect to its existence, right? Many scholars will find it difficult to find out a proper set of criteria as to when a particular practice of state becomes us cogens. There is no specific guidelines, but Vienna Convention recognizes them, right? And it also talks about futures, right? If there can be a new peremptory norms emerging, that also will be treated into existence. And if there is an existing treaty or existing custom or any particular judicial pronouncement or work which goes against that particular futuristic peremptory norms, those will be held illegal. It's a very interesting aspect. But how does a particular practice reaches to a standard of the highest order, right? That is something which many people do not find, like proper understanding, a clarification basically with respect to that, right? Say for example, many scholars have raised doubt. Dhananjay, can you just let in those students? Or yeah, okay, thank you, Mita. So say for example, but it has worked, right? Preemptory norms have been recognized. Some of those have been recognized. For certain preemptory norms, there are debates. Say, for example, with respect to principle of reforma, it is like again a concept which is debatable as to what extent it has been attained the standard of the highest order, right? But We are all in agreement with slavery. We are all in against the practice of slavery, against the practice of apartheid, right? So there are certain piracy for that matter, genocide, right? That's a very important concept which has been understood by world altogether. But the fact of the matter is the relevance and role of International Law Commission, right, over there. So try to read these 26 provisions. It's very easy, right? You can clearly have understanding of what can be constituted as progressive development of international law and what can be constituted as codification, Article 17 and others, right? So it's very interesting piece of legislation, understanding, right? Codification of international law is something which has not been properly referred in international law. Like here and there, small reference will be made with respect to codification. Now we will be coming to the next part, which is legal, like state personality, or what we can, can understand by the concept of subjects of international law, right? So, in order to make a claim, in order to have, like a duty assigned, and for that particular duty, if somebody wants to make a claim, you need to have legal personality. This is something which is also being seen in domestic setup. You ought to be a legal person so as to bring out any claims before the forums that have been made available on behalf of a state. Similar kind of requirement is for like for international law as well, right? There are various methods in which your legal personality can be like determined under international law. There are various subjects, much like the definition which was raised by propounded by Bentham, wherein he says that the primary and sole, like this role is of state alone, right? It continues for a significant period of a time, but at least in scholarly work, there was recognition of other subjects as well. International organization, for that matter, right? Red Cross was the first international organization which is recognized. There is a role, there is a duty, there are certain obligations which have been rest upon that particular organization, and it's a non-governmental organization, right? In Red Cross, for that matter. And thereafterwards, there was this reparation case which we'll be covering in today's lecture, and therein United Nations also attained the status of international organization. The movement is progressive in that particular regard. You will also find reference of individuals. There are Treaty of Versailles, wherein a procedural right for individual has been covered. Many other treaties. I have the list of all those particular treaties wherein individuals has also been given this particular right to bring a claim and enforce those claims as well. Right. By and large, the scope of individual is limited. You have international court, criminal court. Anybody who has been found practicing those prohibitory, like international crimes, because at this moment of a time, international crime is limited to the crimes that have been referred under the Rome Statute. Right. There are many others, many other form of crimes, and there is a movement towards including more, like because only 4 or 5 of those particular crimes will not suffice. This is what is the view of many scholars, but this is what is the progressive development of international law. Unless and until this has not been understood properly by state altogether, you cannot enforce it against the wishes of a state, right? So legal personality holds a very important aspect. You have this particular aspect referred clearly under the domestic setup of any particular state, but for international, under international law, non-state actors are also becoming relevant, right? Individuals are becoming relevant. Non-governmental organizations are also gaining importance under international law, right? They have the duty of not just like claiming rights, but also duty to enforce like certain rights upon others, right? So legal personality to that extent is very relevant for our purpose to understand, especially international part. Now, the term subject of international law refers to the entities which have been endowed with legal personality, and at the same point of a time, they became capable of exercising certain rights and duties on their account under the framework of international legal system. Right. That is what has been constituted as subject of international law. Unless and until you are not subjects of international law, then there are, like you cannot have your rights and duties, and you do not have that particular power to enforce those rights and duties, right, against others. Now, Gabriel Stark, he says that the term, it's not team, it's term subject of international law means these 3 points, right? An incumbent having right and duties under international law, a holder of procedural privileges of prosecuting a claim before international tribunal, and the possessor of rights for which provision is made by international law. Right. So you cannot have, unless and until there is a procedural aspect referred under international law and it assigns you that particular procedural right to claim, make claim, or endorse those particular rights, then only you are becoming a subject of international law. Right. We all know that primarily states are, like there is no doubt with respect to states holding this particular international personality, but there are others also which are gaining importance. Oppenheim says that international person is one who possesses these 2 qualities. A legal personality under international law means who is subject of international law and enjoys rights, duties, and power to establish it under international law, and a capacity to act on international plane either directly or indirectly through another state. So his observation is that, and he was a different scholar altogether. We will find it on the basis of various theories that have been propounded. Oppenheim says that it is largely the state who enforce those rights through its citizens under a particular forum which assigns it of laid down any particular procedure method of claim before such, like forums. Now, these are the scopes and duties of anybody who has been termed as subject of international law, right? They can bring claims, they have the ability to come into agreements, right, which will be binding under international law, right? If you are subject of international law, there will be certain treaties which you can like formulate on your behalf, and thereafterward it will act binding upon both the parties or group of parties. Then you also enjoy immunity, right? Example is diplomatic immunity, consular immunities, right? So these are additional benefits which have been assigned to individuals. So individual and having, like becoming subject of international law, you have these Vienna Convention, right? 1963, 1961, all those that has been formulated in the 60s. Then you became subject of obligations as well, right? Say, for example, you have to make sure that the enforcement of humanitarian law is being taken properly, right? It has been understood properly. Now, the rights, powers, and duties are different for subjects, right? You will not have all the rights assigned to individuals, all the rights assigned to like non-state actors or to non-governmental organizations, but like you will always have reference of state everywhere, right? Because largely the domain of international law is centered around state. It is like transgressing from that particular part to others as well. Say, for example, with respect to granting like immunities to certain public servants, coming within the brackets of diplomat or counselors. In fact, for head of the state, there is no international treaty for that matter or any particular convention as to how like protection can be provided to heads of the state. But this is formal part of customary practices, right? So many people believe that custom has lost all its significance. The grant of immunity which has been provided to heads of a state or certain other public servants representing state is in the it is largely in your it is formally largely being made by customs, right? Customs take care of that particular part. Of course, the immunities which has been assigned or been granted to the head of the state is of the highest order. They are protected even better comparatively to a diplomat, and much better with respect to the like a counselor or others, right? There is third Vienna Convention as well in this particular regard, right? So this is what I was referring to. Now, the next point is there are various theories, right? And largely you will see they've been divided into certain groups. Two groups basically. Why I have referred to groups? Because theories are largely what is realist theory and fictional theory, right? Now, realist theorists believe that it is only the state who are the primary and the sole subjects of international law. Fictional theory, which is largely been propounded by Kelsen, he believes that state is merely an like a more kind of entity which is representing the will of people, individuals, right? And that goes very well with respect to his theory later on when we will be discussing about relationship between international law and domestic law, because Kelsen is of the view that it is monistic. There are others who believe dualistic theories, right? Ancelotti, like so, and he was a judge, very renowned judge for that matter. His belief is that it's dualist. The approach of international law to with respect to municipal law is dualist nature, right? And thereafterward they propounded their own theory. One talks about transformative theory, other group talks about declaratory theory, and that ultimately has its effect with respect to the manner in which our practices, because largely if you'll see our constitution, it is monistic in nature. Like if you'll read say article 53, 73, 253, read with the entries that are referred in your 7th schedule, specifically from entry 10 to 21, right? 7th schedule, nobody has gone through that particular schedule, I believe, but just give a reading, right, to the 7th schedule. From entry 10 to 21, you will find out those entries are particularly of list 1. Those entries are particularly with respect to international relations, right? And that is a domain altogether, like of executives alone. Now, in India also, we have two aspects covered on the basis of our constitution and its reading, along with the entries. One is treaty execution, and second is treaty implementation. Right? Both of these two domains are assigned to two different organs of Indian state, and we will be discussing more in detail with respect to that. Right? Treaty execution and treaty implementation. So, coming to this part, realist states are the only subject on whosoever has been receiving on behalf of state, be it an individual, be it non-state actors, those are not subject but object of the international law, right? They say that they are merely object. They've been represented through state, and it is state which is more important. And now this particular view was contradicted by the reparation case, right? And then you have fictional theory, which says that it is individuals, right, who should be the primary subject of international law, because state is altogether what it is, a common will of individuals, and it is merely representing that common will, and it is therefore, and whatever is there under international law is ultimately affecting the interest of individuals theoretically, and for all practical purposes this particular theory, fictional theory, which is propounded by Kelsen, holds relevance. But in like in reality, this particular theory is again faltering. You have Mavromatis case in this particular regard, right, which is consensus case, right, which started from 1924 to 1927. It's a very interesting case, and to a very interesting and very like interesting part of India, world altogether, which is the territory of Israel as of today, right? So, and it was a mandate state at that point of time. So we will be also referring about mandate state, trusteeships, trust states, right? There is a specific organ in United Nations which talks about trusteeship, right? Now it's not functioning because there is no trust states existing as on today. So what's the distinction between a mandate state and a trust state, right? So we will be referring that in the coming. Now, third is functional theory, which is not, that's why I've referred only two groups over here. It is not a theory, it is a theory which says that everyone is subject of international law, provided there is a specific procedure of international law that assigns them right, acknowledges certain duties, and give them procedural right to get them enforced as well. So that is functional theory, basically the manner in which international law is functioning in present times. It acknowledges the fact that it goes beyond state. It acknowledges the fact that it goes beyond individuals. And there are others as well, including non-state actors, including international organizations. Right. Now, realist theory, the argument is propounded on behalf of positivist doctrine, right? When we were discussing about the history of international law, therein I was referring to this particular term, this particular point as to how positivism or analytical law school gained its importance, right? Largely around 18th century, 19th century for that matter, and early part of 20th century. Because the early part of 20th century saw a revised version of positivism, right? From the efforts of Kelsen, right? He brought out a school of known as Vienna School, right? We also credit Vienna School, and we also believe that it is part of the like analytical law school, but from a different perspective. The scientific analysis of law is something which has been retained by Vienna School, but it does not go entirely does not agree entirely with what other positivist believes into, right? But and it is the result of this particular school. You had this critical legal studies emerging, wherein you challenge the very notion of lawmaking. You say that law do not, law are not the solution itself. They are at some point of time also a problem creator. This is what is a critical law school, right? Law not only takes care of the fact that problems in the society are taken care of, but at certain occasions, it becomes a problem creator as well, right? And they gave various examples to this extent, wherein they said that the law purposely avoids equality with respect to the role of women. Feminist movement emerged from their racist theory, emerged from their critical racist theory that it supports a particular race in comparison against the others. So all those that particular aspect. So realist theory, a product of positivism, which has largely influenced international law, right? From the period of 18th century to early part of 20th century, right? So this is what we have understood, right? Now it says states alone have the political, being a sovereign political entities, the bearers and rights and duties under international law. It is the state. It regulates the conduct of, like an international law regulates the conduct of a state, and it makes them fulfill the international obligation. Now, Oppenheim believes in this particular point, right? He is the proponent of this particular theory. Now, uh, according to this particular theory, individuals are merely objects of international law, right? The recognition of sovereignty of each nation is the essence of international law. Individuals and non-state actors have no place under international law. This is what is the view of realist theory. Now they go a step ahead and they say that individuals are only incumbent of rights and duties at international law. They are not the most important, subjects, but merely incumbent, right? And they lack the procedural capacity to enforce their right. It can only be enforced through state, and this is to a great extent even true in present times. Many a times, if there is a case of reparation which is raised on behalf of a particular state against another state for the kind of injuries that their citizens have received, it is through states, right? A live example is many states, filing case against Iran for the shooting down of the commercial airplane, right? And it has been contested on behalf of state, right? So it is not the individual who can directly sue the state of Iran, right? It has been done through their respective states. Canada filed a case. Many other states, European states, have also filed a case with respect to claim of damages, reparation. Right. So this is what is the theory all about. Now this has been subject to various criticism. Now particularly because you see that uh, there are certain rights which have been conferred, certain duties, not just right, but also duties which have been conferred upon individuals. There's a specific code in, like in America, which allows, it is based on a particular treaty that has been entered between various states, which allows individuals to, like forward a particular claim directly. So, like enforcement of right can be done on behalf of individuals as well. Plus, international organization, right? This is a very important case with respect to criticism related to realist theory. Now it says there is this reparation of injuries suffered in the services of United Nations. It's an advisory opinion of International Court of Justice, right? We'll refer to this particular part later on when we will be referring to the other, specifically to the subjects of international law individually, right? But very important case, and I think it's one of the earliest case of Nation, and United Nations wanted to bring an international claim against the state. Right now, there was no particular mechanism available at that point of a time as to how an international organization can also bring claim against a state. Now, this was a matter which was referred to the General Assembly. General Assembly made 2 points uh, and for those particular points, they wanted to seek advisory opinion of International Court of Justice. Now, International Court of Justice held that UN has the capacity to bring an international claim as against a particular state for obtaining reparation for its agent, right? For the injuries that they have suffered for the under during the performance of their duties under the aegis of United Nations, right? And it rejected altogether the proposition that state and only states can be the subjects of international law and they only can claim on behalf of its citizens, right? Respective citizens. Now, since being a member or agent of United Nations, you have an added benefit, right? Which is what has been formulated in this particular case. There were these two questions, right? The General Assembly passed through resolution, brought these two questions before the ICJ, and ICJ further like narrowed down these two questions into three questions, right? Because there was this new dimension which was also referred in that particular judgment that United Nations not only can bring claim against its member states, but it can also bring claims against non-member states, right? So given giving United Nations a status of super states. It was an early year of United Nations, right? In the recent times, there are various critics who have raised questions with respect to the ability of United Nations altogether, right? They believe that it has lost its significance. They believe that states generally have been following practices to undermine the principles and purposes for which United Nations was being meant to. There have been a lot of effort in that particular, a lot of criticism in this regard, but again, those criticisms are not like factually and legally correct enough. As I've already informed, for all like intent and purposes, it the United Nations has secured its significance. Right. Of course, there are new dimensions which have emerged. Right. The world is going beyond the requirement of peace alone, but it comes back. Right. As and when we believe that like the world order is all economic in nature, right? With the greater like power being assigned to World Bank, IMF, WTO, it is more of a nature of economic interest of states. But we have instances time and again coming wherein peace and order of the world is again important and it holds relevance. Right. In the recent times, we have this Ukraine crisis, right? Which is again, like brings us back to the early years. Like we wanted to avoid this, and accordingly, the measures have been taken on behalf of states. Right, various states they've been joining. So that's why like when you are studying international law, not just the rules are relevant, but there is other factors which are equally relevant and important for our understanding. The political factor is very crucial in that particular regard. But of course, economic matters are also relevant. If you closely watch that particular situation, the manner in which Germany is behaving, it it gives a different dimension altogether. But we'll not go deep into that particular part. These are the two questions which were formulated. The question was, in the event of an agent of United Nations who is performing his duties suffers any injury, circumstances that involves responsibility of a particular state, United Nations and as an organization, do United Nations as an organization has the capacity to bring international claim against such responsible de jure or de facto government. Right. Now, this is something which we will again refer in unit 3 when we will be covering recognition. So there is recognition of state. There are two concepts. One is recognition of state. The second is recognition of government. Right. Recognition of state is again in the basis of de jure and de facto government also. Right. We have been seeing that Taliban is been enforcing and been like putting a petition before world at large that please recognize our government in the state of Afghanistan. There's no doubt with respect to the existence of state of Afghanistan, right? Nobody can question that particular existence. But there are certain states which have not been recognized collectively by world altogether. Many states, there are many states who have raised objections with respect to the existence of state of Palestine, or for that matter, even Israel. Right? They do not recognize many other states. Bangladesh, for its early years, was not recognized by world altogether. The first state who recognizes Bangladesh was India. So that's another game altogether. It's more of a nature of a politics in nature, right? You will, the world will condemn for all its actions that has been done by the existing government of Taliban in Afghanistan. But later and sooner or later, you will find out that the government will be recognized as well. This has already been done by few states, and there is a process which is ongoing towards recognition. So de jure means that you have been recognized legally. Basically, in the simplest sense, de facto is subject to certain conditions, right? And it can always be revoked. De jure cannot be revoked, right? Once you have granted recognition to a particular government, you cannot take it back unless and until there are some new development that took place. And we'll refer to this part in recognition part, right, more in detail. So the United Nations, can it bring a claim against both de jure and de facto government, right, by a United Nations on behalf of victims of the persons who are entitled through them, right? So there were certain deaths also which occurred. So on behalf of their legal representatives, can United Nations claim, right? That's the first question. Right. Second is, in the event of affirmative reply to B, right? How is the action of United Nations to be reconciled with the right that is possessed by the state to which that particular victim is a national, right? So how will you reconcile this? Because the state will say that no, he's the citizen of A state, and I will be filing that case against the other state, right? And that would ultimately undermine the very existence of United Nations otherwise, right? Because if states can do this, what is the role of this organization altogether? So it was a very interesting case in that particular regard. You want to hold an importance to this institution of United Nations, at the same point of a time bring it at the pedestal of state. So this was largely the resolution, the questions which was posed by General Assembly before the ICJ. ICJ framed three important legal issues. One is whether United Nations Charter. So the entire argument was based on the reading of Charter. That's why I always insist to the students of international law, if they can have a pocket edition of UN Charter, keep it with yourself, read it many a times, right? And if not, at least have a reading to the charter provisions. Right? Those are all relevant provisions, particularly your Article 1, which talks about purposes, and Article 2, which talks about principles. Right? And it is all centered around those purposes and principles. If you look carefully, those purposes and principles, any law which is being developed in international law will be covered within those purposes and principles. Right? Starting from cooperation, right, in terms of political, economic, to restrictions or restraint in use of force and all such measures, right? That's what is the relevance of UN Charter. I have already given you the relevance of UN Charter when we were discussing about codification process, Article 13, Clause 1, Subclause A, progressive development and its codification, which ultimately resulted in the making of International Law Commission, right? And it's a huge, remarkable achievement, right? In fact, this entire requirement, like, in fact, if you read more carefully, various scholars of international law, particularly Crawford, you will be like amazed that they believe that it is the because of that particular war, like First World War, Second World Wars, the importance of multilateral, like instruments, the importance of conventions, the importance of preservation of human rights was felt, right? And ultimately, if we look to his particular conclusion, he believes that international law is witnessing a new phase, a new era altogether, because of various, you know, problems that the world has been witnessing in the nature of globalization, in the nature of surveillance as well, right? IMF has a very powerful mechanisms available, economic powerful mechanisms. It can undermine the value of sovereignty of a particular state, and they have been doing it continuously. Whether that was an intent for which the new, like or modern international law was framed, it's something which Crawford believes is has to be, like gone, like somebody has to go through them, right? So these are the questions which was brought, whether, like, can under the charter the organization is in the position to possess for its member, like uh, the right to enforce or claim international personality? Can it bring international claims against the de facto and de jure government for reparation? Can, yeah. The third is how international United Nations can reconcile such rights which is possessed by the victim and its states. The fourth is that can it bring not just against the de facto and de facto or de jure government, but also against non-members, right? Is it limited to just against the members all alone? Can it bring it against the non-members as well? Now the decision was unanimous insofar this particular fact is concerned, which says that United Nations has been provided with certain responsibilities, and the responsibility is mutual, right? So when you read the provisions referred in the, like objects of the, like the purposes of Article 1 and 2 collectively, you will find out that the responsibility is mutual in nature, both the members as well as for the non-members, because those are principles of the highest order. The world, if want to have mutual cooperation, if it wants to have sustenance of peace and order, they have to be not just like confirmed by the members alone, but should be confirmed on behalf of non-members as well. So it says that UN has the capacity to bring an international claim, both against the de jure and de facto government. Further, they said that UN has the capacity to claim reparation in respect of damages that has been caused to the victim or to the person who will be entitled to. So you can raise a claim, you can claim reparation as well, right? You will have the duty to raise a claim. That's within the powers of United Nations because of the reading of Charter, wherein it says that responsibility is mutual in nature. Just go through those previous Article 1 and Article 2 of the UN Charter, right? I have already shared the UN Charter with you in the PDF form in file section. Then the third is that UN as an organization can bring the claim of reparation which is caused to its agent on the ground that it was breach of duty on behalf of such a state, right? And in such a process, it negates any particular conflict. So United Nations will act on behalf of not just that person or anybody who is entitled by that particular person, but also on behalf of a state. It's a it's a very remarkable point which has been referred in this particular case, that you can not only bring a claim against the agent of yours, but also that of conflict, right? So this particular point was quite crucial. Later on as well, if there is a state who believe that no, I will be fighting that case, irrespective of the fact that UN has been fighting over there, it removed any such possibilities, right? It says that it will be fought not just against the interest of its own agent who is performing a duty, legally binding duty, right? But it can also enforce it against such a state to which that person or agent was a citizen, right? So this will ensure independence of its agent, right? Because if United Nations proclaims, and this is what has been done for the past 75 plus years, that UN ensures to the world that it is an apolitical institution, it is not biased, right? At least many of those instances appears to be non-biased, right? There are critics who believe that there is a biasness towards developed or a certain selected few countries, but by and large, the message is that it is not biased. It is an independent organization. You can only claim independence when you can claim right over such an agent. You can only do that when you have the right to not just claim it on behalf of such an agent, but also claim it on behalf of the state to which that agent belong. Act as a citizen, right? So it ultimately ICJ opines that it is the principle of international law that breach of engagement involves an obligation to make reparation in an adequate form. So ultimately establishing the fact that United Nations is an international organization. It is within the rules of UN Charter itself that it grants responsibilities, duties, and powers which are mutual in nature. So UN can only serve its purposes and principles unless and until states are willing to make it happen. And that can only be done when the responsibilities appears to be mutual. So if the purpose is the mandate of United Nations, then the responsibility is of the states to ensure that those purposes have been fulfilled in a proper manner. Any violation of it will bring a case of you know, like will bring a case for its enforcement, and UN has all the right within the capacity of international organization to bring such a claim on behalf of a citizen, on behalf of its agent who is a citizen of another state. So this is what has been conferred by this particular judgment. We'll stop at this. We'll cover fictional theory. So this is a case which goes against the very purpose for which realist school was formed, right? Any doubt so far? I need to hear yes or no.
No, sir.
Okay, thank you, beta. Chalo, those students who have not been marked, raise your hands, beta. Dhruv, Ashika. Dhruv, what's your roll number, beta?
76.
70. Dhruv marked. Ashika, what's your roll number?
60.
60 marked.
Sir, 079 Ayush.
Just a second, beta. Diksha, what's your roll number?
Sir, 102.
After Diksha, it's Vartika.
Sir, 061.
What's your roll number, Manan?
Sir, 059.
59, Manan marked. Then Karanveer.
56.
Nikita, what's your roll number, beta?
Sir, 078. And sir, Somics also.
Just a second, beta. I've been calling the names one by one.
Okay, sir.
Mandeep, what's your roll number, beta?
072, sir.
72. Mandeep marked. From Mandeep, we have Ayush.
Sir, 079.
79, Ayush marked. Then Lavanya. Lavanya, what's your roll number, beta? Anyway. Ayush, I've marked. Somik, what's your roll number? If you are not responding, I'm not going to mark. Then Sashank, what's your roll number, beta?
Sir, 101.
To Shashank. Khushi,
So 92.
Arihant, what's your roll number, beta?
Sir, 056.
Okay. Marked. Then Ria, what's your roll number?
086.
As many number of students joined late. To be strict with attendance also. One or two students is still understandable. But almost roughly around 10, more than 10 students. Yeah, those who have been marked, they can leave, beta. Lavanya and Somik, I have not heard anything from you. You are
Sir,
there?
Somik has written his attendance in the chat box.
Okay. Why he's not responding?
So he's unable to unmute himself.
So what I can do, Somik, you need to switch on your camera and Lavanya as well. Then only I'm going to mark your attendance, otherwise not. Okay, Somik is there. Okay, Somik, what's your roll number? Somik's roll number is what, beta?
Sir,
Take care.
74.
You need to log out from your account, beta, so that your mic is working properly, right? Once in a week, you need to do that. Yes, Lavanya, you need to switch on your camera. Okay, what's her roll number? Lavanya का roll number क्या है?
Sir, 103.
Thank you. There's still one student who has not been marked. Anyway, Rehan,
सर
तुम कब
068
ज्वाइन कर रहे हो?
सर बार बार कॉल ड्रॉप हो रही है
068.
0 सर यस सर एम आई ऑडिबल
Yes, you are audible. 068. Okay. Chalo, marked. Thank you. Quickly go to your next class.
sir.
Thank you.